we doing?
Your Honor, I was just going to ask for a short adjournment here. Just going to look in to see if we can get him. Sorry, I don't know why I always say here.
I don't either. I don't know. Because I guess you asked for adjournments there too.
Yeah.
All right.
Yeah, I need to request an adjournment just to see if I can get him into
May 16th, 2024 without objection.
May the people consider that bond?
You may.
Thank you. Your Honor, at the time the defendant was arraigned, he requested a $50,000 surety bond, and that would rate the insurance defendant $50,000 surety bond with 10%. I think that the asking the court to review that for an abuse of discretion. This is the defendant's 11th or 12th OWI. So we can see his priors are from 2020, 2018. There were two in 2012. 2005, 1995, 1993, 1992, 1989, 1988, and 1986. And specifically, he got for OWI.
What year?
2022. The concern of the people is the rest of the public of the defendant. Professor plays on the scrum cutter and there's been no indications that he's violated. That's right. Corrections this morning. But this pervasive and ongoing history of OWI is of extreme concern to the people, the safety of the public.
Your response.
Oh, Your Honor, Mr. Radke is a Navy veteran, disabled veteran from 1982 to 1985 with an honorable discharge. He's Michigan born and raised. He resides in Wayne. He regularly attends AA meetings. Last time he attended an AA meeting was yesterday, and he attended 2 of them. He also let me know that he voluntarily has looked into checking into an inpatient treatment program in Detroit. I believe it's called Life Challenge Inpatient Treatment Program. It is Christian based. And he let me know that.
How come he isn't in an inpatient treatment program now?
Well, Your Honor, he has been going to AA meetings, and it's an up and down battle with Mr. Radke. And
I understand that, but I also understand that he served prison time for drunk driving. Was released in 2022.
21.
And by 2024, I'm back here again with this. Right?
Yeah, that's correct, Your Honor.
What was the alleged BAC in this matter?
Yeah, that's a really good question. We're still awaiting the blood results. This was a single vehicle crash that occurred. The defendant.
There was an accident?
Yeah, he crashed, a single vehicle crash. And the defendant
Mr. Allen.
all field sobriety tests, all PBTs, and the blood, as the blood draw as well, and we get a warrant. So we're still waiting on that, but we did charge the case given the history. And I will let the court know too, that at the time that the defendant was booked into the Washington County Jail while awaiting medical examination, he did submit to a PBT at the jail, which was a 0.147.
That was at the time, 147 at the time of booking?
At booking, that's right, Your Honor. But of course, the court knows we won't be able to use that number for our case, but that was the PBT at the time of booking.
Anything else, counsel?
Your Honor, Mr. Radke was arraigned in front of the Honorable Magistrate Fink. I believe she appropriately set the bond here at $50,000, 10%, with a scram tether with a no drinking, no driving standard bond conditions. Yes, there was an accident. Nobody was physically injured. He has been on scram.
We had a blessing.
He had a blessing, but nobody, from what the alleged report says, nobody was injured. He checked in today early at community corrections. His agent is Mr. Levitt. They downloaded they gave him a main base device for his home so he can continually test at home. He has had no issues since he's been arraigned. He is compliant with all of the bond conditions here. And he's
Counsel,
here.
you say that to me, but we're a week out from arraignment. It's a week.
I know, Your Honor, but I'm just trying to.
No, go ahead. You make your argument.
Yeah, I'm just trying to let the court know that Magistrate Fink heard both arguments. I believe she set the bond at an appropriate bond. If Mr. Radke would have known that the bond would be raised, he would have never posted a $5,000 bond that he had to use on his credit card. His son, he had to call his son here. His son is in the courtroom now, trying to take care of these matters. I'm just asking this court if it would have any leniency for Mr. Radke to allow him to continue to do what he's been doing and get these matters taken care of here.
I believe that given the defendant's record in this matter, given the fact that we don't have the test back, but he was almost a 0.15 at the time that he was booked in, that further that there is an accident that has occurred. Also, given the defendant's record that he had just come off parole, basically in 2022, we're back in 2024. He's done this again. This is not by any stretch of the imagination necessarily an attempt to punish the defendant, but I believe that the defendant, he may be trying his best to do what he's doing, but what he's doing right now gives the court serious concern or pause. I don't believe that the magistrate in setting the bond, I think that there has been an abuse of discretion. I'm going to set the defendant's bond in the amount of $50,000 cash or surety bond, no 10%. I will, however, do this. Make a decision. You said that the money was paid on a credit card of some type. I don't have a problem refunding the bond that he's paid if he needs those funds to pay for inpatient treatment. So he can be released to inpatient treatment. I'm phrasing it that I'll consider release to inpatient treatment. I'm not saying on a PR at this point, but if he needs those funds and you let us know that he needs those funds to get himself into inpatient treatment, I'm not going to have a problem with that. I want him to have help. I want him to not deal with I want him to be able to deal with the demons that face him. And I don't want him here on an OWI causing death. And I think that I need to protect the community, and that's how I'm going to do it.
Okay, Your Honor. Can I ask to approach, please?
You may.
Thank you.
All right, record should reflect that we had a bench conference just in terms of the details. And again, so that I'm very clear on the record, I don't have a problem refunding what's been paid, provided that goes to inpatient treatment.
Okay.
All right. And so I just need you to arrange that, get with the prosecutor. You guys give me an order and I'll sign off on it. Make sure if there's a cost to the inpatient treatment and you want the bond returned for the payment of that, make sure that portion is contained within the order.
Yes, Your Honor.
All right.
Thank you.
Thank you. Defendant is remanded.
I'll give you.
Court calls case of the people versus Carla Berg.
On behalf of Ms. Bird, who approaches.
She's waiving her right to preliminary examination.
That is correct, Your Honor, and we would like to respond at the appropriate time.
Briefly, we'll be able to respond. Ma'am, you're waiving your right to preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over on both counts. Your turn.
Oh, thank you, Your Honor. I'm sorry. I was just writing that down. We acknowledge receipt of information. Wait formal reading, stand mute at this time.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pre-trial will be set for
October 29th at 1:30.
October 29th, 2004, 1:30. As to bond.
As to bond, Your Honor, my client provides that she would be able to stay at Travis's stepmother's home in Clinton Township. She gave me an address for that. Mr. Bogan, I'm sorry, Travis. Travis is no longer in the area. He went back to Georgia. I know that when we did the violation hearing, some of this stemmed on initiation of contact from him with the one of the alleged victims in this matter. He is not going to be an issue in this case anymore. She's asking for an opportunity to be out, at least on home confinement. Your Honor, she is pregnant. She advises she's not getting the best nutritional care at the jail, certainly. She provides that she would be fine with the home confinement. I'm concerned about her stress levels in the jail. I understand that last we were here, we discussed that on the record somewhat, so I'm not going to go into too much detail about that. She does have an OBGYN appointment on the 15th of November she would like to be able to go to, however. So I'm just asking for an opportunity for her to be on home confinement. Again, she's not going to have she has no problem not going to the football games. That's not going to be an issue for her anymore. The preliminary testimony provided that there was no contact between the two of them. I know that there won't be regardless. She's not going to be putting herself in a situation where Chloe could show up at a home where she happens to be at either, because she would be out of the area entirely.
Response.
I'll try to keep it brief, Your Honor. Your Honor, this court proceeded over a bond violation hearing. I wasn't here for that, so Your Honor is more aware of the details than I am. But what I do know is that there was at least 2 clear violations. Minor victim involved who is already scared, already had to witness something terrible at the hands of this defendant, already is in a horrible situation with her father because of the defendant. This defendant is a grown woman. She needs to start acting like it and stop blaming other people. She has made decisions, despite this court's orders, to go to events that are related to the school of this minor child victim. Her attitude has been very poor regarding this matter. She has not taken responsibility by way of at least changing her behavior. I understand we're in an active pending case, so she's limited in that regard. I completely understand that. But to sit here and try to blame someone else, I have no doubt that this Travis person is doing a horrible job being a father and is doing a horrible job mitigating this situation. However, we don't have jurisdiction over him. We certainly don't have jurisdiction over Chloe, the minor child involved. And she should not be held responsible for avoiding this defendant. There is no reason she was at those football games at all. And I have little doubt that she would continue this behavior. And I'm not sure exactly if I picked up on it correctly, but it sounds like she's going to be staying with family members of the victim because that is the biological child of Travis. So I'm not sure how that would make any sense.
I don't think it's going to work. And I hear you. And I listened to Chloe and heard everything from it. I'm not even sure why this is being raised again, because it's not going to happen. Motion for bond reduction denied. Bond will continue.